first 4 days of 2020 market.
Writ petition is dismissed.
We to be allowed to move a tomorrow.
Motion.
I beg to mention for the actual matter. The Honorable Court has already admitted the process permit me on the 2nd June
Item, matter of which year?
2024.
24, what is the urgency?
Here is this is my whole
Sorry, no out of turn. Mention memo is only for urgent matters, not for listing matters. Yes, next. Sorry. If you, if there is urgency, you can express, we'll allow, but not as a routine manner. Yes.
I beg to mention item number 30.
1-3.
Taken both the others.
Yes.
It's meant kindly pass for
1-3. 13. 16 matter, madam.
My senior, one hearing matter is going.
But this 16 matter, how can a hearing matter take precedence over the 16 matter?
My senior
This is also hearing.
only pass for the day.
No, 16 matter, why do you pass over? How do you, after this is 2025, 9 years. We'll have it tomorrow. Or day after tomorrow. Item number 13. A prayer for adjournment has been made on behalf of the petitioner. However, considering that this matter is of the year 2016, a slight accommodation is granted directing listing of this matter on Thursday, date. Day after tomorrow, don't take the adjournment. Thursday.
with the concept of other let's mention item number 7 and 8.
7 and 8, which matter? 15 matter?
Is out of this lot. Any period, my lord, if the lordship permit,
Day after tomorrow.
on Friday, he is out of, he will be reaching on Thursday. Or in 5th May, he will be available. If lordship permit on 5th of June, hearing day, my lord.
See, these are all 14, 15 matters. We have noted. Simply giving a advance notice is not enough.
Right.
That is only intimating the other side. A prayer for adjournment has been made on behalf of Sri P.J. Saikia, who is stated to be out of station. Full stop. However, considering that these are all matters, do matter, huh? A slight accommodation is granted directing listing of this matter on
5th lordship permit.
5th. Why 5th? 3rd. 3rd.
On 4th, my lord. 4th,
4th.
my lord.
4th June.
5th of
Yes.
Take to mention item number 15.
Yes, 15 and 16.
Petition by both the part or by
But these are also
It's
old
like-
matters. Old matters. Why are
Yes,
you
ma'am.
taking time? Old matters are listed before this bench on instructions. Why are you taking time?
I have both with what
When? Day after tomorrow? Day after
Okay.
tomorrow. On a prayer made by Sri B.K. Singh, Learned Counsel, for the petitioner in WPC 2429 of 2020, a slight accommodation is granted directing listing of this matter on Thursday. Yeah, for the other
Can it be,
side.
my lord, in first of the week of June, my lord?
In
First of week of
on 3rd of June.
Fine.
3rd is
already
a
fixed matter is there on for 2nd or 4th.
oh, 4, not on
second-
4th. Then we'll
second.
have it on 5th of June. 5th of June. No, you are suggesting a motion the dates. Don't put a motion date.
On 12th,
10th.
10th.
10th. 10 June. 10/6.
alright.
Yes, appearing in person.
Yeah,
Which matter?
I beg your lord, lordship indulgence for taking of today.
Which matter?
Regarding my lord,
Fresh matter.
yeah,
You are seeking permission to move.
Yes.
What is the urgency?
Well, urgency is, well, there is a certain deadline tomorrow.
For?
Regarding the certain e-chalans, that there is arbitrarily being issued by the police department regarding no parking violation and other things, well, resultantly, I am not being able to renew my pollution certificate, and that is fixed for deadline is tomorrow. So there are certain
You pay the amount that will be subject to the outcome of this. How can we stop payment of a
No,
challan?
my lord, because they did not follow the motor vehicle.
Those will examine. But can you prevent, can you say that I'm not going to pay, examine?
No,
We'll
I'm not
examine.
saying that, my lord.
If tomorrow you are successful, you'll get back whatever.
That is what, my lord. I am not saying that, my lord. I was waiting for a summons to be issued by the honorable court, my lord.
Hmm.
Because, my lord, they were supposed to send it to the jurisdictional court, and they did not. Even I did not receive the SMS, my lord. I got it. I get to know it from the e-portal, my lord. called
See,
M-
these are practical problems we realize, but
But, my lord,
we
the
can examine, but
pollution
how
certificate, my
much
lord,
is the amount?
my lord, 10,000 for the pollution, man, and rest are, my lord, for no parking, which I have not violated. That is the
No, those are factual disputes.
That's a fact. But, my lord, as per the new motor vehicle amended rules, my lord, they need to, my lord, take a photograph from the
No, Mr.
specific.
Chakraborty, we have not said that we are not inclined to examine.
But-
But the aspect of urgency, that means you want an interim order. Interim order, what is the interim order that they don't want to pay and the matter has to be
No,
examined?
I simply pray for extension of time. That's not,
Difficult.
eventually it will out- it
We'll
will-
see, we'll come, bring your petition. Bring your petition, we'll see.
I have filed, already filed. At 2 months,
Yes.
my knowledge.
Item 18 for withdrawal.
May I tell, but I may be allowed to withdraw this file.
What was this matter?
While a matter clerkship against the NIT.
You were found to be successful in the
Lord,
bid, then
what happened on my lord?
work order has been issued now.
What was not good lordship? Matter was it, some errors has been occurred.
Some
Hero lord, that, but
error,
lordship.
what is the error?
There is the in a synopsis, but the synopsis statements of some other cases. So I may be allowed to file a step.
Okay. Your AMS Mazumdar,
Lord.
Sri AMS Mazumdar, Learned Council submits that due to inadvertence, there is some error in the synopsis of the writ petition, and accordingly, he begs to withdraw the same with liberty to file afresh. Para? Upon considering the prayer, writ petition is allowed to be withdrawn with liberty as prayed for.
Okay.
Item 1.
Mr. Pang,
Contextual amounts for the
file the affidavit.
yes, affidavit has been filed.
When?
Filed on 22 facts.
Okay. What do you say in your affidavit?
Take up forward.
Yes, we have seen paragraph 4.
Subject.
Who is appearing for Revenue Department? Revenue? Yes. Hmm? Yes. No, what about the stand of the department in the affidavit? We want your response to this. We'll fix a date. Let him take. Have you been served with a copy of the affidavit?
Not.
Okay.
Not.
Let us issue a short notice. Okay. Heard Sri J. Payang, Learned Counsel, for the petitioner who has filed this writ petition for the release of contractual bills. Full stop. As per an order dated 2/5/2025 of this court, comma, the respondent number 6
Six.
has, who is the Deputy Commissioner, District Commissioner of Lakhimpur, has filed an affidavit on 22/5/2025 in which certain averments have been made regarding fund position in which the Revenue and Disaster Management Department would also have a role. Full stop para. Let notice be issued, returnable on, give a date. Yes, tell us.
Week.
Today is 27. We'll have it on, we'll have it on 16th, on 16th of June. Sri S. Datta, no, Water Resource. Yes, D. Jain. Ms. D. Jain, Learned Counsel appearing on instruction of Sri R. M. Das, Standing Counsel Water Resource, accepts notice on behalf of respondents 1, 2, and 3. Finance, H. Aliha 4, Finance. Revenue Disaster S. Datta 5,
Five.
and 6 is M. Chetty. Let extra copies be served upon the Learned Counsel for the respondents by tomorrow.
Okay.
Item 2.
My lord, the railway was directed to obtain this construction.
Yes. It came on 19/5.
Yes,
Yes,
there was a limited order, my lord,
yes.
whereby the bank guarantee was asked not to be attached.
Yes, what do you say? What do you have?
The right to take over the site. But Site of it,
The site was not taken over by him.
no, that is not the order, my lord. Order is that, my lord, there was delay in execution of the registered joint venture agreement. Public order publicly made has to be construed in the context in which it is made.
Yes, Mr. Datta.
My lord, by their own conduct, they have waived their right, my lord. As a matter of fact, when the LOA was issued, we were permitted to go ahead and we have proceeded with the work, my lord. Art filling work has been commenced. If your lordship should kindly come to the LOA at page number 141, my lord.
Yes.
Please come to page 142, my lord.
But what about arbitration clause?
No, my lord, arbitration clause, my lord, Supreme Court has made that position very clear. And here in this case, the arbitration clause cannot survive because, my lord, the arbitrator would be their own person, covered by the Supreme Court judgment.
No, that part can be taken care of. But
My lord, it's not a case which involves any disputed questions of fact, but as a just interpretation of 2-3 clause of the agreement. Now they say there was delay. Now, by their own conduct, my lord, they have agreed not to insist upon all this consideration. For example, first come to page 142, my lord. The part of the LOA, and you see, normally when can we commence work? First, we have to give the performance guarantee. There will be execution of agreement.
right.
Because of the urgency involved, my lord,
Hmm.
they have done otherwise. Please come to 142, the first subpara.
Hmm.
The entire work shall be completed within 730 days from the appointed date as per Article 26.1 of
But
the.
what about the reasons which have been prescribed
Huh.
in the impugned order of that you had failed
Huh.
to furnish the original joint venture agreement?
That is the only ground.
What is your response to that?
My response is we have given it, my lord. The unregistered one was given along with the tender. Subsequently, it was given. It was given on 5th of March 25. And thereafter, the agreement was executed on 7/4/25.
Well, it was given beyond the limit, 140 days delay.
My lord,
And
they are
it-
counting it from the original
My lord,
schedule. But by their own conduct, my lord.
We
they
also-
said-
Okay, we'll issue notice
Huh.
at this stage.
Huh.
Heard Sri K. N. Chaudhary, London Senior Counsel, assisted by Sri A.
Very good.
Gautam. for the petitioner. Full stop. The petition has been filed assailing a notice dated 5/5/2023.
Miller, 25.
5/5/2025, by which the work of ... देख लीजिए, has been terminated. Full stop. It is the reason cited for such notice is the inability on the part of the petitioner to furnish the original joint venture agreement.
The registered one.
The original registered joint venture agreement. It is the case of the petitioner that though along with the bid, an unregistered deed was submitted. Subsequently, the deed was registered, and the registered deed was duly furnished to the railway authorities.
On 5/3/25.
5/3/2025. Full stop.
And thereafter, Miller,
It has also been contended that the subsequent conduct of the respondent authorities gave sufficient impression that everything was going on in a smooth manner.
yes,
And all of a sudden, the impugned notice has been issued. Full stop. Para. This court, while considering this matter on 19/5/2025, had directed the learned counsel, Sri Datta, appearing for the railways, to obtain instructions. Full stop. This court had also provided that till the next date of listing, the bank guarantee furnished by the petitioner should not be encashed. Para. Sri Datta, the learned CGC, has submitted that as per instructions received, the petitioner was not able to take over the site. Full stop. On a prima facie assessment of the written instructions placed on record, it appears that there is disparity between the reasons cited in the notice and the written instructions. Para. Be that as it may, let notice be issued. Returnable on
Project. The 10 days time. We have got. All.
Okay, well, give short notice. Returnable on, tell us when. We'll have it on 9th of June.
Miller.
Okay, 9th of June, returnable on 9th of June. Sri Datta, the learned CGC, accepts notice on behalf of all the respondents.
Yes.
Not all the respondents. IDFC has
5 is IDBI Bank.
1 to 4. Let extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent number 5 by registered post with AD. Steps by tomorrow. Para. The interim order passed earlier, on 19/5/2025, on putting the restriction on the encashment of the bank guarantee shall be operative till the next date of.
I have one more small interim, but they might resort to blacklisting on the plea of this. That no further coercive action till then.
Will they?
Yes, Miller.
Uh,
In fact, we have been informed.
Further, it is further provided that it is also provided that before taking any further action, that no further action be taken over the petitioner without taking leave of this court.
If you-
Why have you filed caveat? Because an interim order needs to be passed.
It was.
If you file a caveat by the railways, then interim order would be passed. You
If-
standing counsel, why do you need to file caveat? We don't understand. No, why? Will you pass an order without hearing you? Otherwise, it's not urgent. Otherwise, we'll not hear you. Why do you make matters very explicit?
With regard to the waive of the submission of the joint venture.
Okay, we'll examine. Okay.
Also, there are both.
Caveat has been discharged. Caveat not discharged. not discharged.
It was not told us, not aware that.
Let us take the pleasure of discharging the caveat. Heard Sri A.K. Datta, learned standing council, learned CGC, who has lodged this caveat in respect of a notice dated 5/5/2025, whereby the contract with the petitioner, with the prospective petitioner has been terminated, full stop. The caveat would be heard in the event this court proposes to pass an interim order. Caveat stands discharged.
Arjun Shri,
Mr. Goswami?
Just reading the the case is the husband of the petitioner. He was an employee of restaurant number 4, Abhishek.
Hmm.
Husband of petitioner was an employee of restaurant number 4, Abhishek Mott. He had worked in that organization from 2006 to 2012.
Employee of Abhishek Motors.
Abhishek. He was an employee from 9th of June
That's what number?
2006 to
As Abhishek is response number
restaurant number 4.
4. Since when?
Since 9th June 2006 to 13th August 2012
9 June 2006
to
to
13/8 2012.
almost 6 years.
So he died in an accident on 13/8 2012.
Yes.
So after his death, Lordship, he was posted at Tezpur.
Hmm.
After his death, Lordship, the petitioner, Lord, she was absolutely helpless. She had to fend for herself, not even thrown out her husband's house. So for some time, she could not follow up regarding the benefits of her care. She was not even aware of the fact that the husband was that was a ESI registered organization. And accordingly, he should get benefits of ESI. So on coming to know about it, some old colleagues of her husband, she applied to Lordship, wrote to Abhishek Mott. Lordship, all these letters, Lordship, from me, she wrote to her first, wrote to them first on her list of dates on
Okay.
9/10/2017.
17.
2007. And thereafter, Lordship, she kept reminding. Also, she also informed number 2 and 3 in this case, ESI. From 9/10, the next letter was on 25/10/2017, then 13/11/17, 19/1/18. Finally, he got no response from Abhishek. Then finally, Lordship, respondent 2 and 3 had to write to Lordship Annexure 10. Had to write to the thing, please provide her the EA. She was not provided any information, whether her husband was an insured employee, was registered under the ESI Act, to even make a claim for Lordship.
Who wrote 2 and 3 means?
Lordship 2 and 3 at the ESI regional office and the branch office.
Page?
Page number cost that Lordship. Page 2 and 3, Lordship. He is the deputy director.
No, which page is the communication?
Commission Lordship Annexure 10.
Page?
Page number 10. Page number Lordship 51. And they had to finally caution that necessary will be initiated against as per rule. Complaint received from Minaki Borua Saikya, late Dr. You are hereby advised to clarify whether late Diganto Sturkar was an employee of your factory establishment. Despite lordship, I have been writing from 2017. This is a letter of 2019. If yes, why did you not register him within 10 days of his joining in your factory establishment as per provision laid down in PSI Act 19? The petitioner, widow of late has alleged that her husband has served in your company from 9/6/2022, but as you have not registered her husband under his cases for which he is being deprived of the benefit by the Act. Hence, you are advised to clarify the above situation within 15 days of receipt of this letter, failing which necessary action will be initiated as per. But despite that, lordship, at least I did not get any communication. I think subsequently they informed the year that he was not registered under the lordship. When I filed this petition in 2019, lordship, and this was my case that my husband was an employee and yet he was not registered. And lordship, it's I have mentioned in my petition, lordship, I have shown given the year. They have been registered. Now it has come from an RT application to the ESI. ESI has given me all this information which I have annexed as annexed 13. All these documents. They've given the returns filed by the number 4.
That is for so far as the registration of the unit is concerned.
Unit was registered in 2000.
Yes.
And for 12 years till the death of my husband, only after my husband's death, they started filing returns. They have been a defaulter. ESI has been just turning a blind eye. They used to write to him, remind him, but did not file any return till after it was in September 2012 only they started filing. So maybe it's just to take advantage of that particular fact. His name was not there. His name does not appear as a list of secured person in that returns filed by the respondent. After that, lordship, the respondent 4 took a stand that petitioner was not registered because he was posted in a non-notified area, that is Udalguri. My case has been that he was always posted in Tezpur. And also stated even if he was posted in here, I'll come to a specific. Even if he was posted at Tezpur, because Tezpur is a non-notified area, he would not have been covered under that. This person has also been supported by 2L. When I again filed affidavit in reply, showing very clearly, lordship, that Tezpur was a notified area since 1969, and that my husband was never posted in Udalguri, and the appointment letter which was enclosed with their affidavit, respondent 4's affidavit, does not show that it was ever acknowledged by my husband. And when the Honorable Court by this order dated 9/10/2023, lordship, may come to this order of the Honorable 9/10/2023. Honorable Court, lordship, passed a gave a direction to the respondent number 4.
Order dated
9/10/2020.
9/10/2023. Yes.
Mr. T. Goswami, Learned Counsel, appearing for respondent number 4, gave slip of the court to bring on record the additional documents, including a joining report of the petitioner's late husband under the respondent number 4 concern. He prays for time to permit him to bring the additional affidavit. The court is inclined to grant the prayer of the respondent number 4 to file the additional affidavit. However, made it clear that besides joining letter, all relevant documents pertaining to the petitioner's late husband, including the salary statement, other benefit, letters of posting, etc., be included in the pleadings by your petition affidavit sought to be filed as prayed for. Sir, this is non-appears for ESI. Lordship, after receipt of this, lordship, respondent number 4 filed an affidavit. Lordship, it's a continuous effort to deny benefits to me. I mean, lordship, what has happened in this? They have taken a stand that all the documents are lost. The additional affidavit filed by respondent number 4, they page 159, 160. 160.
Yes.
I respectfully, paragraph number 4, Lordship. I respectfully state that, as already stated in my affidavit in opposition, the husband of petitioner late Diganto Stoikia was appointed as self-executive in our company at Udalkut. The records pertaining to the joining report, salary statements, and other benefits and posting are more than 10 years old, and the same are not presently available with the company. Lordship, this petition was filed in 2019. It was not 10 years old at that point of time. I've been writing to the astronaut force since 2017. The matter has been in issue, Lord. It was not a date issue. That because it was 10 years, they have destroyed it. It was not 10 years at that point of time. Neither at the point of time when I had approached them, nor when the ESIC was taking up we were taking up the matter with him, questioning him that for a year. And also when I had filed this petition in 2019. Now, this is not a correct.
This more than 10 years is in the context of the date of filing the additional affidavit, which was in 2024.
Yes.
The additional affidavit was
In
filed in
2024.
March 2024.
Yes, sir.
So from the context of that date, it perhaps is not incorrect to state that it was more than 10 years old.
Okay, but they should have kept in mind, Lord. This is a live issue. I filed a petition before the High Court, where they are a part. It automatically ought to be there to keep this record. This is a High Court matter. And also, I have been, they should have been sensitive to this particular point. This poor lady has been approaching them from 2017. And Respondent 2-3 being controlling, not controlling, but authorities as the ESI is concerned. They are also seized with the matter. They wrote to him during this thing. Respondent 4. So, Lordship, my is that this statement, Lordship, does not appear to be borne up. Because it was not 10 years when the matter was live. Even if it was more than that, dragging on, it's a live matter. That simple, very easy plea ought not to have been taken by it. And Lordship, I have also given some documents to show. Now I'll come to my point, Lordship. I had filed 2 affidavits, Lordship, in which case, Lordship, my idea was that when the appointment letter is exhibited by him, next slide, it does not carry my husband's signature. They should have come with a joining letter when he has joined. Normally, when people are so starved of job, the moment they get it, they sign it and they also give a joining letter. Now, dispute is whether he was posted at Udalguri or Tezpur. Tezpur is a notified area, but probably out of ignorance or deliberate here, Lordship, they said Tezpur has become notified area in the year 2016, unless on record. So when I challenged it, Lordship, with TA, then Respondent 2 and 3 finally sent me a letter. I have annexed it here. That the Tezpur was notified 1960 to say that it was not notified in 2016. I don't know if it's ignorance or deliberate. That has been so now. There was even if he was posted in Tezpur, he would not have been covered. And I'm denying that I was ever posted in Lordship. I, as a petitioner, I know. I used to accompany my husband to Tezpur when India, 2 of you, in fact, worked in the seminar in a very nearby organization. So I, my personal, I know he was posted at Tezpur. It's for them to now say that he was posted to prove that he was always posted in Udalguri. The case, Lordship, where it all started because they have been defaulters. If they were law-abiding companies, Lordship, I would not have suffered because I could have, when I was alive, my husband was alive, my husband would have stood for his rights. That's why my name is not included.
But to claim,
It all happened for 12 years, they were not complying with the regulations. And they started when only after my death, my husband.
but was any contribution made from the salary of the
That
husband?
was the point. I said, no contribution made from anybody's salary, but they included other names. When they gave the return, they gave the returns of about 100 odd employees.
No, if under the Act, ESI Act, how is the corpus made? It is from contribution. The employer has to contribute. The one part has to be contributed by the
Yes, yes,
employee.
Both sides.
Now, if your husband was not even registered, there was no contribution.
That is the point. Why was not paid? Because had they been law abiding, lordship, they are compliant, law compliant organizations, everyone would have been registered
No.
from 2000.
Now, practically,
2000 is-
what relief will you get?
No, no,
Suppose
that is-
we say, suppose that their action of not registering you is bad in law, then what would be the consequence?
that they should, since they have given the premium backdated for everyone, Lord. For existing employees, because for 12 years they did not file returns. It's for the 2
No,
and 3
the
to
question
confirm.
of, that.
When they had paid for others, they could have
No,
paid for me also.
Mr. Goswami, paying for others and paying for a deceased employee without there being a contribution of the deceased employee, this will perhaps not fulfill the definition of contribution as per the act, which envisages one part by the employer, one part by the employee. Now they are taking a stand that you are not registered because you had worked in a place which is not notified, which you are disputing.
Yes.
You say that Tejpur is a notified area. You should have registered me, but because of some ignorance or whatever, you had registered yourself, but you have not registered the employees. You had done it backdated for other employees by the time your
Yes,
husband has
That's
passed away.
exactly what.
Now, your husband has passed away. During his tenure as a salary holder, no contribution was made in the name of ESI.
They are provision the act. When they ESI brought it to it, they can collect premiums over it. Maybe he was not there, but
No, that is the reason we are trying to just discuss and deliberate. Person has passed away long back. There is no claim of any salaries or pending. You are only saying that since my employer is a registered ESI unit, I should be given the benefit of the act. Now, to give the benefit, the contribution from your husband was a mandatory requirement, which he had not done. Suppose we hold that action is bad in law. What would be the consequence?
they can pay for
Mhm.
what was legitimately due to be. They have I'm suffering because of their
No, how do you assess what would be the amount?
and
There is no contribution from you. They had also not contributed. They say that you are not registered. We find fault with them. Then what would be next step? Can we say that now you have to, some amount has to be deducted from you, which you have already passed away?
there
How
can
is
be
it
nothing
possible?
to regularize, deduct that whatever amount would have been from my. They can deduct it from the amount benefit. They can deduct that amount, whatever I would have
No,
paid
after
if I was
passing
alive.
away of
If my husband was alive, whatever would have been due from me, that could be.
so your husband has passed away more than a decade back. Now, can you turn the clock back? You can you can sue for compensation damages. But here, you just think over. We are not against you. We want whatever is entitled you should get. But the writ court, what is the provision in the ESI Act 1948? If in spite of your entitlement to be registered, you are not registered, then what do you do? What is the provision? There has to be a provision.
See
in
that
the-
if someone is not registered,
Yes,
willfully his an acceptance has been made.
yes.
Maybe lordship 20, what I have heard lordship, there have been some cases who have been regularized and but they were alive. It's
Yes, who is
they
appearing?
may be able to, they
Yeah,
have
for the-
kind of some answers in there with them.
Smith is for the ESI.
Hello.
Just a minute, Mr. Goswami, for the. Can something be done? Without even going to the legality. See, we do not know how much Mr. Goswami would be able to make out a case. But at the same time, we cannot totally ignore or overlook the practical aspects. Because the aspect of the husband of the petitioner serving for around 6 years perhaps is not disputed. Only on that consideration, we are thinking if something could be done. I do not know how much legally he'll be make out a case to get effective relief. We may hold this to be not in accordance with law, but we have not even heard Mr. Smith. We do not know what is going to.
So the merit, the loss of it remain. The question of fact, was put or in Nalkut, section 75.
75 is there, that we know.
Say that but he has saying that he is not
I
registered. And there have been many orders by this court, including your lordship. After
No, see, every orders are passed have to be assessed on the basis of facts and circumstances. Here we are dealing with a widow who has lost her husband way back in 2012, isn't it? 12. And this writ petition itself was filed into 19, I think. Now, after 6 years, if at all we have to relegate, we have to do, but without relegating, can something be done? We are just asking.
Yeah, but
Yes.
75 Lord, I have checked 75. My case does not fall within the case laid down.
I was just wondering, this court was just wondering whether 75 would be applicable.
Lordship, I have each and every point of 75.
Let us read
Not to
75.
Lordship. First thing, it relates to all live persons, like your Lordship had just said what to do when someone is denied all the his existence has been denied. It's a case where someone is an employee. I'm an employee, no doubt about it. But I'm not an insured employee. If I'm an insured, and what is my contribution to that? I'll give it and probably I'll do and pay. It's a case where I'm not in the picture. 75, I have gone through all the criteria of 75, 1, 2, 3. My case does not fall within this parameter. None of this, Lord.
And you also have a bar under 75(3).
75, he also left between years. No court shall civil. It's a
You
yellow.
cannot readily go to the civil.
As far as decided by medical board.
PI court.
But she is not an employee.
But here, if I may read this, here where he comes. If I may, Section 75G, any other matter which is in dispute between a principal employer and the corporation, or between a principal employer and an immediate employer, or between a person and a corporation. Person. It was the white. Even if he's saying he's a person.
It doesn't deal with employer and employee.
It's
It's
a question of fact.
not, again, this is not an employer and employee. It's the concerns then with corporation. It's the employer and the
Any other
corporation.
matter which is
Not with
in
employee.
dispute
Yes,
between
employee.
or between the principal employer and an immediate employer, or between a person and the corporation. And between the person and the corporation. He is not aggrieved by the corporation. His grievance is mainly against the employer, her grievance.
He has to be to even avail the benefits, but he has to be good person and an employee. That's what
Now, if what Mr. Goswami is pleading is factually not disputed, that this unit, respond number 4, was indeed registered with your corporation. In spite of this, the employees, for some purpose or the other, some reason or the other, they were not registered. And it was done on a subsequent date, giving effect from a prior date. In the meantime, the husband of the petitioner, he passed away. How do you address this now? It cannot be his fault that her fault that her husband was not registered. And unless you are registered, you also cannot say no contribution has been taken from him. So how do you make a claim? That is a very easy recourse we can take, which you had asked. And at the same time, to make a direction that the contribution part you adjust, this may be far-fetched, maybe. Mr. Goswami, how can you resolve?
He was employed. Not, but employed.
Have you annexed any documents of his employment? Filed on
filed on January
page?
page 8.
No, running page. Affidavit in opposition by whom?
by response number 4.
81,
Annexure B.
81.
Yes, sir.
Annexure B.
Annexure
What is the name of your husband, Mr.?
Diganta
Diganta
Saikia.
Saikia.
Okay.
Government notice.
Yes,
Annexure B.
circle. Is it 12, 12? Is it
12, 12, 12,
Yes.
12, 2017.
Yes, yes, please.
Lordship will just turn over to 4 pages.
Yes.
Here, there is a list of partially implemented states and union territory.
Hmm.
Serial number 2, Assam.
Yes.
Lordship will come to the third column,
Hmm.
or fourth column. in fact.
Non-implemented.
Udalguri, my lord, it was implemented on 1/4/2017 only. Her husband passed away in 2012.
Now, where is the document to show that her husband was indeed posted and working at Udalguri? And vis-a-vis Mr. Goswami, you have to show any documents. Do you
Lordship
do you
will
have any documents?
I'm
So I'll
come to Annexure A,
Yes,
the very first annex.
please.
This is the appointment list.
Okay, at Udalguri. Udalguri you have
Yes.
mentioned. 4/5/2006. What do you say, Mr. Goswami?
I'm disputing the genuineness of this here because for one reason, Lordship, it also comes out from it. If entire records are lost, why is this letter preserved and filed in the year 2020? It doesn't bear the signature of the husband of the petition. No joining letter, not even an acknowledgement in this. It appears to only one-way traffic.
No, in that case, this will be difficult for us. You may be correct. You may be correct to contend that the genuineness of this letter you are doubting.
Yes.
But writ court, as you know, our
It replied to me otherwise long time back.
no, this writ court limitations, you know, we cannot enter into those questions. Are there any other documents? What is the documents? What are the documents you are trying to project
Yes,
and
Lordship,
rely?
because I have filed with tape, but
In your writ petition?
in my affidavit, Lordship, when they have denied, then I have been forced to take this, Lordship. Two. One is, Lordship, that page 154.
154.
154, Lordship, it's when I had petitioner had applied for LIC benefit and it required certification by the employer. This certificate by employer.
Hmm.
Here is written Diganta Saikia Village Borgogia Bhaya Visa, Sales and Marketing, Tezpur branch. Which they are trying to say it's a fabricated document. I don't know, LIC, my petitioner is not that resourceful to manipulate this kind of document in LIC.
I
And
was
the
saying,
same HR manager, Lordship, had given that first annexure one of my affidavits. Same person. He had given HR manager, he had given me the certificate that I was an employee of this. They can dispute it, but they have to give also other year.
my contention is
Just a minute. What is this in this 154? What is this record of absence? 154 on the left side down. What are these dates? 3/11/2020, 2006, So 13/8/2012, record of absence from duty.
Date on is the list is last attended duties, 13/8/2012.
No, thereafter.
There,
This third row
record of absence from duty, that
during,
is nil. That was something that there's not absent. That
no.
from 2006 to 2012. Record if he was absent from duty.
No, 2006 to 2012, you are absent from duties,
No, that is nil.
not nil.
All, I think doesn't mean that
Record of absence
It-
from duty. I think
it-
they try to
the
infer.
period of his employment.
Then why is it written record of absence from duty during the
The
period?
period from it. I think that's the standard query probably to find out whether a person has been sick, ill, or something. I think that's to find out.
Okay,
Take
the expression nil which has been used is for all the queries.
for all the queries.
Yes. But here you are relying to show that your husband was indeed at Tejpur.
Test proof.
But
They are,
again,
would not have signed it otherwise. They have not denied the signature of the HR manager.
but
The
again,
HR manager must have signed a bill, completely filled up.
no, that is okay, but again, it will be disputed questions of,
Yes,
You are
I understand.
you are disputing the first letter. You say it appears to be manufactured. Because when they say that the entire records are missing, from where do they retain?
Why did they return only this particular? Entire documents are missing. The previous year, how could they produce?
But we cannot come to give a finding on that aspect.
The
On the genuinity of a document, we do not have, neither have the expertise, nor we are asked to, required to.
yeah, I understand this. But
Yes,
Yeah.
can something be done? Many things will come up now. Again,
yeah, immediate package lordship, they are big.
I'll have to take instructions.
take instructions. If you can settle this matter, it may not be to the expectation of the petitioner, but you are having some issues. Children, no children,
I have a daughter,
daughter.
only
How
mother and
old?
daughter.
How old?
She is in college.
College. Try
Because
to do
our
something.
petition is hardly 40 years.
Try to do something. Okay,
Is the petition, I
take the instructions.
just got.
Because once we say that we are unable to do anything after 5-6 years, or when the petition is pending. Okay, third, Sri R. Goswami Learned. Heard Sri R. Goswami, Learned Counsel for the petitioner. Also heard Sri M. Smith, Learned Standing Counsel, ESIC. Whereas Sri Goswami, D. Goswami has appeared for the respondent number 4. Union of India is also there. Anyone? Okay. First of the Union, R.K.D. Chaudhary, Deputy SGI for the respondent number 1, Union of India. Para. This writ petition, which was filed in the year 2019, is with regard to a claim of compensation by the petitioner whose deceased husband was working with the respondent number 4. Full stop. Such compensation emanates from the Employees State Insurance Act 1948. Full stop. The claim is however disputed by the learned counsel for the respondent number 4 by contending that though there is no dispute regarding the employment of the husband of the petitioner with his client, such posting was at Udalguri, which was not a notified area under the Act. Full stop. The aforesaid contention is, however, disputed by the petitioner, by the learned counsel for the petitioner, who has even alleged some manipulation in the document sought to be relied upon by the respondent number 4 in making the aforesaid contention. Full stop. Para. Be that as it may, comma, since the employment of the husband as such is not disputed, and also the fact that the respondent number 4 was registered under the Act, comma, Sri Goswami, the learned counsel, is directed to obtain instructions if the matter can be amicably settled. Full stop. The aforesaid direction is, however, made without touching upon the merits, inter se merits of the parties to the dispute. Full stop. This, after 2 weeks,
Problem.
try to come up with some proposal. Let's end the matter. Not reflected. The name of Sri M. Smith, learned standing counsel, ESIC, be reflected in the cause list.
Problem.
Let. As a transport protector, but NIT was good. The losses comes to page 48.
What is the matter about?
Better, my lord, they have given a less distance in the tender, my lord. But actually, later on, my lord, the committee formed and they found that distance is more. We claim for the more distance.
Okay.
Actually, two division bench judgments are there.
Covered.
But
Yes,
But
but
later on, my lord, what happened? They have again, my lord, formed a committee. Subsequently, can it be done, my lord? Well, this is they no, there are 3 routes, but the first committee found, my lord, that 2 routes are not available for the trucks to move, my lord. The first committee found only 1 route is available. And now they say, no, there is another.
Mr. Singh, is it covered by division bench? If it's a division
My
judgment,
lord, because now
is
this,
there a scope to distinguish? We are bound by divisions.
no, my lord, there is good judgment against that judgment that not be that as
Supreme Court
my lord,
has,
subsequent fact, my lord, that another committee has stated that the that road was 6,005. So the kilometer which was mentioned in the NIT was 59.
what you say is that the route was suppose A kilometers, but while executing it was found more than A.
Yes,
Then you had made a claim
no,
accordingly.
they formed a committee
Yeah.
and the committee found that, yes, it is more.
More, okay,
3 routes are there, but 2 routes are not motorable for trucks.
okay.
That the committee has found.
That
Committee's
Now they
report,
say, no.
committee's
because
report is
still-
there. Committee's report says that the route which you have to undertake
Yes.
is of a greater distance.
Get that.
Then what about the findings? Not
Well, 2 restrictions were allowed on that basis, my lord, actually, and they have paid also. Now, in my case, my lord, when the judgment, my lord, they, again, my lord, they happened to another committee and say that, no, on the maps, my lord, if the losses will see those, my lord, this committee report, my lord, how they have done it.
If it is decided, Mr. Singh, why don't you pay?
Facts are little bit different.
Facts will always be different. But if the principle is the same,
Same.
if the committee says that the other
Now,
two,
my lord, another committee is there, my lord, it says that it is 92 kilometer, and that report has not been challenged by the petitioner.
They do.
but earlier committee, why didn't you adhere to the findings of the
We
earlier
have taken
committee?
action, but there is a GRC report which the petitioner has approached the GRC. In that GRC report, stated and there are taking action against that member, my lord. Another committee report with the supporting documents, my lord. That route was, shorter route was available at that.
You have taken action against the earlier
Yes, my
committee.
lord.
What
In the
action?
affidavit in opposition,
What action?
in the
No, what
affidavit in
action?
opposition, we have categorically stated.
Simply saying that you have taken action will not do. What action have you taken?
I can brought on record, my lord, what action they are being taken.
No, if it is covered by DB, why should we again ponder and waste your time, our time?
My lord, I will try to convince your lordship, it will not be a waste of time. Because the petitioner has approached for the second time earlier, DB bench has stated, and that DB bench has also not been challenged by the petitioner. Wherein it has been categorically stated, my lord. If I am allowed to, I can submit.
Then if you want to us to hear, we'll hear. Okay.
Hello, they have issued a NIT method. Page 48. For carriage of
4-8.
Hello?
4-8.
But for it.
Just a minute.
Find serial number 4. That is,
This
my lord,
NIT is at 3315, is it?
yes, yes. Serial number 4, my lord, is the tender in respect of which, my lord, we have submitted our bid.
Yes.
That is the losses C, Ex Railway Siding, Salchapra to FCI FST, Chandrapur, Tripura, via way bridge. This distance is 292 kilometers.
Yes.
Now, on that basis, my lord, we submitted our bid, consulate bid, and as per the, because, my lord, they have to, suppose we have submitted a bid of for the entire distance, they will calculate, my lord, it kilometer per metric ton, and thereafter they find the lowest one. Accordingly, we have found to be lowest. Accordingly, my lord, we have accepted Sevigam has been issued. Your office may come to page
72.
74.
What is 74?
That is the, my lord, they have accepted our bid and they have given the order.
Work order.
Yes. Reference to tender so for the appointment of transport contractor, excellent citing to FSD Santos weight bridge distance 292 kilometers on regular basis for a period of 2 years. You are quoted that of rupees 2759 so only has been accepted and request to furnish security deposit comprising a sum of 5% of the vehicle value capital. Accordingly, we have submitted file.
Yes.
And later on, my lord, they have issued the final work order, which is at page 79. So that is only formality.
79.
Yes.
2/6/2015.
Yes.
Work order. Yes, thereafter?
Now, thereafter, my lord, we started carrying the, my lord, place. We found, my lord, that the distance is much more. Accordingly, we submitted about 6 different sums for them, my lord, page 81 onwards.
Yes.
What is the one of that, my lord? With the first time, we would like to inform you that the distance indicated in the state NIT, actual distance is different. We request to verify the distance by company authority and there is no actual difference that will help us calculate that. Well, similarly, we have filed 5, 6 references, and thereafter, my lord, they have appointed a committee. Committee has, my lord, not only for my sense, all that sense. That is at page 89.
Yes.
My lord, I shall place that at 89. My lord. As per FCI so and so, the undersigned committee members, RO as well as GO Silchur, proceeded to verify the shortest motorable distance.
This is committee report
Committee.
dated.
There, my lord,
Okay, doesn't matter.
now, proceeded to verify the shortest motorable distance from railway siding to Salchapta via especially Nagar, Nandan Chandapur, and ex railway siding Bihara, Chandapur.
It is okay. Number yours
Now,
is number
The
4.
only thing I want to show, my lord,
343.
yes, that is correct. But the second paragraph is important, my lord. The starting point was taken from beginning of Salchapta siding and proceeded via Weybridge. So and so, at the beginning point, the Salchapta siding was not possible to complete single day. The committee decided to break total journey into some milestone points. The milestone road distance measured recorded by the committee based on the digital meter,
Mile meter.
mile meter, had take. Well, they have one mile there. Actually, they have found it, and they have given the report that it is 343.2.
Hmm.
Now, in the bottom mile, you shall also see
Yes.
there are 3 ways.
Hmm.
That's the main road, national highway via Kaline. But out of that, lorries, trucks can fly only in one road. The other 2 roads goes to populated village areas and private tea estate, and is not possible for the trucks, lorries to fly via those routes. A clear cut finding, and they have given the maps also at page 90 and 90.
Yes.
So, this maps also given, they have actually, my lord, gone there with the vehicle and they have calculated. Thereafter, my lord, we calculated, my lord, they refused to pay the amount. So, we approached this honorable. This honorable court high judgment, my lord, at page 93, allowed the same, directed them to pay the amount.
93.
90.
Who had approached?
We have approached, my lord.
After this committee.
Yes, sorry, I'm sorry, my lord, at page 108.
108.
The operative court.
This is your petition. Earlier 3138.
Yes, that was allowed.
What was the relief you had claimed?
My lord, we claimed the relief for the distance of 343.2 kilometers. And that was granted, my lord, at page 113.
11?
113.
Yes.
Prior to that, my lord, another contractor also approached us in similar manner.
Hmm.
That judgment is at say 90,
90?
90,
At any.
any.
93.
They also same relief as that. Now they have preferred a writ appeal against our judgment, my lord. That also as well. And in that case, my lord, in our case, the rule division bench,
But
Okay.
in your case, the first order of 22/5/2019, if you come to 113,
Yes.
this learned single judge has also mentioned
yes,
that the appeal filed against any order was dismissed.
Yes.
At 113, kindly come to the penultimate paragraph.
Yes.
At this stage, penultimate paragraph,
yes,
at this stage, it may be mentioned that against the aforesaid decision of any respondent preferred writ appeal 316 dismissed. That was also taken into
my lord.
consideration.
That was it.
Earlier case by any had attained finality.
Right.
Following that, your order was
Right.
passed.
But in my case, the division bench, my lord, they preferred a writ appeal. The division bench took a view, my lord, that there is a dispute redressal committee who should approach that part. That judgment is at page 1.
In the appeal preferred by FCI against your judgment.
Right.
Okay. Just a minute, against. Your judgment was 22/5/19.
Yes. Division bench 24.
FCI. Filed. Writ appeal. Where is the division bench? Page?
114.
Next page. 36 of 2020.
Yes. And that was disposed of on 24/20. My lord, the division bench took a, my lord, view, my lord, that there is a dispute redressal committee and you should approach that. Party portion is page 128 first.
Operative portion where? Page
Page 120.
120,
128.
128.
It is opted.
Yes.
The opted committee on reference the matter it would adhere to the principle of good faith as explained above. For the good faith between the contract parties should be impliedly inherent in the conduct of every party to the contract. And to send to that
Yes.
dispute redressal committee, my lord, was taking a matter, my lord, did not dispose of, we have filed a contempt thereafter, my lord, they have both contempt also directed again. And they have missed our defense.
Not maintainable.
Thereafter, my lord, we had a deed path again, that which is at page 148. The same was disposed of, my lord, yesterday, at page 1.
Where is the order of the,
Page 150.
no, order of the dispute redressal committee?
My lord, that is there, my lord, at page 140.
1? Yes.
Now, my lord, we again prefer the read pistol, my lord, which is page 148.
This is 144 is the order of rejection.
Yes.
Then you filed writ again.
my lord.
You had again filed a writ petition.
Yes.
Challenging this with 17/8/2022.
That
This
is
is-
6618, my lord, that is 140.
Yes.
My lord, at page 150, my lord. Just short further order. The petitioner was allowed transfer to work for against respect to my department, actual work was less transmission was to be done respect to 343. Accordingly, the claim that the he paid additional amount for extra scripture that for heading to our interim order makes it stand up that the respect of petitioner was equal to perform the transmission work for certain additional scripture but not taken into consideration while rejecting the claim. The respondent make a statement for the court that the state demands of petitioner duly examined and order passed
Again examination.
again time. Again, my lord, now they have checked. Actually, my lord, they have checked it on the ground, my lord, that the they put the amount for 92. But then this,
Where is the rejection page?
my lord, the page is, my lord,
Page?
my lord, start from the page 150.
26/2.
Yes.
Fresh rejection.
Again.
Grounds?
Ground, my lord, in fact, my lord, that book. So this type that the ground is, my lord, that we have quoted the contrary that for the entire distance of 292 kilometers. That is why. But in another description, my lord, it is a bit that didn't mention that there also the contrary that but they were. I will place the two judgments of the High Court. My lord. Sorry. Okay. The first case, my lord, that is disability of 1/6 of 2018. Para 15 is the main, my lord. Suspect.
316, you want to place 316 first? Or
Oh, yes,
30?
316, my lord, that judgment, my lord, to consider as disability.
Yes.
Now, second case is, my lord,
Now
Uh,
here, what has been held?
yeah, my lord, that appeal has been me, I think, my lord. So, there is a, my lord, the contractor is entitled to, my lord, that for the that of 295.1. They have put it 240. There are last, they said that there is nitrate there for after the that was that got the contact time that of but that of I and not for
And the next one, same.
next one, my lord, is 26th of 20. If the lordship see, my lord, here, paragraph 2, last part, my lord, that page 3. So, my lord, that case, my lord, correct. Because last subparagraph, it, it page,
Just a minute, just a minute. This is order dated what? What is the date of the order?
date of the order is
9/8.
9/8.
Paragraph?
Paragraph 2 starts at page 2,
Hmm.
but I am coming to, my lord, page 3,
Yes,
second subparagraph.
yes, yes.
The register respondent has submitted his in respect of the work mentioned in detail number 5, parting to expenses, however, having sense of 230. The reported that the distance to be covered by the in the route to which the respondent has submitted it was 230. As such, the respondent quoted the amount of which 2549. Here also, my lord, the bid is quoted for that. So taking the distance of 230 in accordance with the tender condition of the report, the rate quoted by the lead prisoner respondent was converted into per MT per kilometer, taking the distance as mentioned in the expenditure, which work out to at 10.98 per kilometer per metric ton per kilometer. Accordingly, lead prisoner became the L1 bidder and the work was awarded to him on completion of the award. Now, the lordship, my lord, the main practice, my lord, the lordship becomes para 11. Our case was also considered, my lord, that at page 7.
Page?
Page 7. Right. Here that earlier that judgment was considered also, my lord, there are 10 at page 7.
Yes.
This being the position, FK cannot change its stance and act controversial food. The decision when judgment case is not act was the case contractor has not approached the advanced legal term and court dedicated the contractor to put the judge to judge the company for taking it advance. Not only that, decision when on this observed that based on the rate quoted by so court may not judge the case. However, presently is not a case which involves in the exercise of case. The original rate quoted by the respondent contractor was converted to per metric ton per kilometer by F. The issue involved here is whether the actual things that convert in the description of work was correctly quoted that tender to not whether a contractor entitled to claim additional payment for extra distance as derived by the constituted by it. More particularly when findings of the committee are admitted by itself. In view of the matter, the work arising out of the so has extended brief to stipulate this contractor taking a fund to the case of the respondent getting just unwarranted. More so, when SBI has complied with the judgment that was harder, the constitutional committee whom the respondent moved the pending advances, taking claim for payment that has not cited the claim, even though it took 5 years past. Thus, the state immunity does not appear this immunity as constituted. So, this judgment actually covers my case. So, I have also quoted for the entire case of same.
But what about the observation that in the initial round,
Yes.
where there's a distinction on facts, you had not approached the grievance.
That is why, my lord, I have approached the gentleman directed me to approach the grievance. I approached, they rejected my twice, my lord, on the same ground that they will not. When they themselves said, my lord,
No,
why?
you have to clarify one thing.
Yes.
The grounds of rejection
Yes.
of your approach to the grievance redressal committee after the first rounds of litigation, including the DB judgment, saying that you, instead of the High Court deciding the matter,
Yes.
you go to the GRC. You had gone to the GRC, GRC has rejected, that is the cause of action in the writ petition, that we understand. But are you contending that on similar circumstances, the rejection of GRC was done so far as the other two cases are concerned? And
No.
therefore, the ratio in those cases are applicable to you.
So, here, my lord, PRC has detected on the ground that they put a rate is constituted rate for entire distance, not per kilometer or per metric. So, on that ground, they have rejected.
No, the rejection so far as the two other cases are
No,
concerned.
they first one, my lord, did not go to the second one, my lord, it was not disposed of for 5 years. That we have also seen, my lord, just the last page.
But here, without even going examining the reasons cited by the GRC,
Yes.
can you allow your petition if you are saying that those are facts are different?
That is, my lord, the PRC has rejected. I'm just reading out.
Yes.
Father refers to so that the contract was finally appointed by the movement of ground as surplus so date quoted by the contractor is 2759 per metric ton for the entire distance, and the same remains as contractual date by which own definition is not dependent on the distance apart from the same. It also remains the fact that contractor Anup Trade Transport who opted the original system of rate quoting the rate per metric ton per kilometer, which contain the distance the FI only left open that was either to accept the rate quoted by the Anup Trade or reject the same, wherein the latter was variable rate. So the contractor awarded to Anup Trade the quoted rate which is sacrosanct. Well, on this note, well, that we have quoted constant rate, not per kilometer per mile, but they have calculated well, for the purpose of finding out who is the lowest. Similar thing is done in this piston also, this second retrieval. Same thing. Your losses has seen, my lord, the first mistake, page, my lord, 2, page 3, I have shown, my lord, your losses. Well, here also he has quoted 2549 for the entire page 3, my lord, the loss. And thereafter, my lord, the FCI authorities bring it to per kilometer per metric to find out who is the lowest. In my case, it has been done. And I was found to be lowest. Only on this down, my lord, the food special committee has rejected my. Now, my lord, if the lawsuit comes, my lord, they filed the affidavit. First time, my lord, they have brought some facts, my lord. I'm just the repetitive question at page 164. Your lordship may come to the committee report, my lord.
Page,
Page, my lord, it starts at 204, but their finding is at page, my lord, 207. Para 4, my lord, at page 207. However,
207.
Yes.
Which one? However,
when examined from maps,
yes.
the route from RS Saltapra Sondapur, when route to Saltapra siding via Webris, Bodarpur Silchar Prison, Eliamuda, FKFC, Sondapur, was approximately 290 kilometers. This could have been the shortest motor road as specified at Silchar. The road so and so, therefore leading to increased rate. This is now, my lord, 2015 contract, my lord, now they have, my lord, wanted to bring, and another affidavit in file, I shall place, my lord, that was. They have filed a petition there also, my lord, we have also shown, my lord.
Can you read this again at
Yes, my-
2007?
Yes.
And thereafter this next paragraph
Yes,
also.
my-
As per this distance
Yes.
remeasurement report and RO level committee, please
Yes.
read. As per the.
As per the distance measurement report, parallel committee route followed by the committee was Saltapra sighting by Webris to Bodarpur Ghat Silchar, diversion point to via Bayarpur Highway bypass point Tripura, via National Highway, via Chandrapur bypass to the. Thus, the distance along the road was considered to be 343.2 kilometers. Our level committee considered only NH8 for the entire. However, when examined from maps, they have examined from maps, my lord. But earlier committee, they themselves went there, well, by taking vehicle. And they have given the report, my lord, that the two routes are passing through, my lord, some villages and tea gardens, and it's not motorable, my lord. That cannot move there. Then one addendum has been also given by this committee. Sir. That has been annexed, my lord, by them. The lordships come to, my lord, take up their agenda affidavit at page 238.
Page?
238, my lord, their agenda affidavit. They have submitted affidavit saying that, my lord, many routes are being now developed. My lord, every time, my lord, the government is taking steps, my lord, to develop the route. Now routes are developed. Now can they take, if the lordships see the addendum at page 244.
Page 220, 244.
244, my lord, addendum they have given correct. That committee.
Yes.
There are two, my lord.
Yes.
The object, from currently existing major district roads and other district roads in the state of Tripura, which may constitute currently the shortest motor freight route as on August 2023. This committee could not ascertain if the roads were existing in 2015 and is conscious of the fact that some of them were non-existent in 2015. Therefore, no comments were made on this route.
Yes.
The observation of the committee on the on the possible shortest along RI and Chandrapur are based on state highways and national highways like 2015, not 2015. My lord. Now, next page, your lordship. Next, paragraph 5. The committee has not physically measured the actual shortest distance along the route RS Salchapra, FSC Chandrapur, as was not mandate of the committee, but it has inferred that there is a significant error in the RO level committee report on the distance measured as the route chosen was not optimal. RO level committee considered NH8 and they considered the existing state highways, so and so, so and so. Same of- Now they have manufactured a new case version. After when they found that second appeal judgment came, my lord, that is in my favor virtually, it hurts me. So now they have come with this and your lordship has seen, my lord, they have on the maps, my lord, and they have not actually gone there. But earlier committee went there, my lord, physically. And they have found that, my lord, these two routes, other routes are there. They have not said that these routes are not there. But these tracks cannot move there because these are strictly populated villages and big. My humble submission, my lord, this fee, my lord, is not maintainable at this stage, my lord, because it's a contract of 2015. At that time, my lord, the committee has timed out and two judgments, they have already paid, my lord, amounts on the basis of that court. Several contracts. Humble submission that, my lord, because we have also filed an affidavit by stating that many routes were developed, my lord. I've given the maps also, but I am not bothering to your lordship, my lord, for that. Because many roads are there, my lord, in our villages also now. The roads that pakka, my lord. Now we have to go very important. Earlier, my lord, we could not move there, except on cycle or motorcycle, my lord. Vehicle could not move there. So, my lord, my submission that, my lord, this report cannot be taken by lordship because they have taken this subsequently because the earlier report they have accepted. Now they cannot, and when they have paid to various sectors.
It take a second.
Page 45
But it
of the writ
Okay.
petition.
of the repeat.
Yeah, for all the respondents.
Step one. Step one.
Okay, what has happened? Page 48.
But it yeah. But it but doesn't it I think I come to page 49. Down below the box matter. At page
Yes.
below the matter the rate should be 40. as per the MT per kilometer as per MTF. The rate is quoted otherwise itself converted to per kilometer take. as- My lord, if the contractor gives a lump sum to assess the L1, that's 55 kilo.
Which,
Now
okay.
at page 52, page 52, my lord, it is the general information to tender, the part of any Roman 2.
No, 49 we have not, please clarify again 49.
49. The rate should be quoted as per MT per kilometer as per MTF. If the rate is quoted otherwise, shall be converted to per MT per kilometer. Here the minority bits quoted the rate not as per MT per kilometer, but as a whole given a lump sum amount for the entire distance. So it has to be converted to be per MT per kilometer, it was divided. And also to assess the price betment of the meters come to L1.
MTF means
MTF model tender form, say agreement
model tender,
tender form.
which should be. Model tender form. If it is quoted otherwise. How is the conversion done?
Some set for 9
Per MT per km.
per MT per. Here the has been quoted this rate as 759 per M. And written in the price bid for that. So we have divided it from
Quote
9
quote is 2759.
per M for entire.
But Mr. Singh, that is okay. See, the assessment while the bidder assess his bids, he will arrive at this figure taking into consideration the distance. Now the distance as per your first notification was 392 or something. 292. And accordingly, he has given this 2759 per MT.
For
Okay,
entire.
for entire distance.
My lord, before quoting, there is a general information tender also. Which
52.
tender must get themselves fully acquainted with the size of the godown. It Roman
B2.
yes, ma'am.
B2.
Roman.
B2.
Yes.
B Roman 2.
The
Yes.
tender must get themselves fully acquainted with the size and location of godown, reserve loading, unloading points before submission of the tender. The rates quoted by the tenderer shall be deemed to have been done after such acquaintance. No tenderer will be entitled to any compensation arising out of any misapprehension. Before tendering, the tenderer must also get acquainted with the conditions of the route be taken by him for transportation of grains, etc. Once the tender is submitted, the tenderer will be deemed to have been fully acquainted himself with the route, and he will not be entitled to any compensation of road blockade, diversion, etc. on the. So we suppose that that he must have gone to the route and have acquainted themselves with the route and also the distance. Now, my lord, again, at page, take your lordship to page, my. They're all part of the tender.
62.
Roman 13, Roman 18, pound kilometer rates.
Rates.
All rates will be treated as firm for the period of the contract. No escalation whatsoever shall be implied or either accept provided subclause regarding the escalation.
But this is not an escalation. He's not,
This is not an, I'm not contesting.
Ah.
I said the rate will be firm.
whatever rate he has quoted, he's
It-
abiding by it.
is-
He only
yes,
says
ma'am.
that
The rate
distance
will
is
be
different.
firm. Then my lord, page 70,
7-4.
70. The 70 gram, he has been appointed. The rate 275, which is in the brand has pointed out.
You're reading 74.
Page 74.
That is the work order almost, no?
70 gram, my lord, informing that you have been appointed and you have been selected
29-4.
for appointment of the transfer contractor on regular basis for a period of years, quoted rate of 5 rand per m. Accept.
Communication of
acceptance.
acceptance.
Rate has been accepted and thereafter one letter was issued.
Yes.
This is that page 70.
That I think Mr. Sayola has.
I will point out one.
Hmm. Yes, please.
In the middle part, my lord, you are hereby appointed transport contractor. Rail at
Yes.
Satyaprat, FSC Chandrapur via way bridge on regular basis with repeated fact at the quoted rate of 759 per MT only on terms and conditions as contained in the standard. Agreement. And he has been appointed as per this rate at 759 per MT. Having found as
You have
my
read which, fourth paragraph?
fourth paragraph, my it starts from you are hereby appointed
Yes, yes.
transport contractor rail at Satyaprat via way bridge on
Yes,
regular
yes,
basis
yes,
with effect at the quoted rate of 75 per m.
yes.
He has been appointed as per 75 per.
Hmm. Yes.
Now, directly, my lord, as pointed out by my senior friend, there are about the restriction thereafter we file and read appeal. That is the 2022.
That those are the.
Yes, ma'am, I'm coming to read appeal.
Wait, please.
114.
Now, writ appeal have ultimately relegated them to the grievance.
Certain points, sir.
Page
Page 107.
117.
1. So, the senior friend has heavily relied on any tweets. Para 7, page 107.
This is part of what?
Part of the judgment of the writ appeal filed by the FCI against the, that is writ appeal number 36 of 22, against the learned single judge.
The initial order which was in favor of Mr. Sahiwala.
Yes. Three paragraphs. Paragraph 7 is the
Just a
Okay.
minute, just a minute. This is against 22,519.
against 318.
No, 22,519.
Yes.
Judgment dated
Yes,
22,519.
ma'am. Dated 22/5.
Hmm. Yes, what? Yes.
Para 17. Para 7, page 7. The contention of the learned counsel for the appellant said that case or that case further contractor was cited finally by the standard. There was anti-trade transport cited on so different so much as the case rate as in that case rate quoted by for transportation per MP per kilometer. That circumstances with regard to the difference only the rate already quoted per MP per kilometer was to be applied. Whereas the case in hand, the quotation given by the respondent contractor is 759 per MP for the entire sub so in terms of the tender.
Yes.
So here anti-trade and this one is different. So there is quoted specifically per MP per kilometer. Whereas here it is 759 for the entire. Now, my lord, paragraph 10, it's sort of paragraph, page 120.
Yes.
So far as judgment rendered in 316 is concerned, there is no the rate quoted was rupees 11.41 per MP per kilometer. In such circumstances, in regard to the kilometer measured by the committee, only the rate was to be kept. So far as the case in hand is concerned, as noticed above, rate quoted by the contractor is not per MP per kilometer, rather 759 per MP for the entire distance given that is 290 kilometers.
Yes.
Para 11. Question that arises for consideration before this court is as to whether the rate jurisdiction, the rate court does in reassessment of the rate in particular facts of the company's topic. So, my lord, thereafter, Jagdish Mandal, Ronak International Tata Cerebral Search, and para at page 125, my lord, up to para 125 here. Page 125, para 4.
Para 14.
Para 4. At page fear of considered view.
Yes.
Fear of considered view that the case in hand would not fall within the realm of cases in which as the rate court could interfere in particular facts and circumstances. And my lord, para 16.
Mr. Singh, why are you reading this? Ultimately, this was relegated to the GRC. Now they are
My
agreed by
lord,
GRC.
Here thereafter.
The writ is not a writ
thereafter
that
the
we are
opted for going
we are
with
not
GRC.
reassessing, we are not reassessing rates here. We are only examining the legality of the GRC decision vis-a-vis the judgments of this court rendered in two writ appeals.
Also, my lord, the other committee report comes.
Yes.
Yes.
But that committee report is not on a physical verification, what Mr. Sahiwala has emphasized.
I'm
It is
coming.
mainly on
Oh,
maps.
My senior friend has skipped one.
Oh, please show us that. We need not go through
So, my lord,
this.
in that case, rate appeal, it's an update for going to GRC.
Yes, he had gone to
Because what the
GRC.
court has said. It's there. So, my lord, in the affidavit in opposition, paragraph 8. Same thing, my lord, I'm relying on, my lord, this, my lord, count, my lord, para 4, 8, 12, 13.
May you justify your decision in the GRC meeting, which is the subject matter of challenge. That much. What has happened has happened.
My lord, GRC observation has quoted my affidavit in opposition, at page 1, 4. Start from 1, discussion and that, 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 it.
Yes, now.
Page 184 is short, my lord, 8.8, relying on 8.8 at page 1, 6. Para 8.
8.185.
8. 8.1.
It will be 185. 8.8 starts with after joining.
After joining
185.
on 5/2015, contractor started contract work without any reservation or objection. Paid the bills of contractor work for the of the pipeline for that reason and not as per and or the scientific property their bills method at the 1. It is to raise it at 275 per not as per
Those you have submitted.
with their thereafter method 2.15.
Yes.
1. Contractor performs contractual work in pursuance of the appointment letter that is at the quoted rate of 759 per metric ton. There is absolutely no mention of at all in the appointment order. It is thus
Hmm.
8.16. None mentioned any an appointment letter. Here enough that the can was only for the purpose of aligning the rate at no other purpose at all. 0.17. Constitution of committee for undertaking measurement of the of contractor because provision of MPF as that the no provision for measurement of after the award of the contract. Rather, on contrary, paragraph 18 of terms and conditions governing the contract contains categorical statement that all the rates will be treated as firm for the case of the contract and no exception whatsoever shall be in order except as provided under clause 8.19. Other words, rates to remain firm for the period of the contract. Of was purpose 8. Business concerning the NIT by when contracted for present.
Mr. Singh, why don't you read the impugned order, the reasons? We'll go by the reasons cited in the order.
So my lord, ultimately, DRC, after having observed that rejected the execution of the GRC. So my lord, coming to the addendum, page 244.
244.
244. So that the paragraph 20
Of
of my affidavit in opposition. is not met.
192.
That's so
Yes.
that it is submitted that the FCI Zonal Office any by communication dated 2023 directed Regional Office Assam to take action as deemed fit against the person responsible for fixing the for the remeasurement of the distance after the award of the contract. Accordingly, a committee was constituted consisting of two categories by Regional Office Assam. So, my lord, by that, my lord, this remeasurement was again done. The addendum, I'm coming to the addendum, my lord, at least
Page?
244. Para 3.
Yes.
The observations of the committee on the possible shortest motorable distance along with the route RS Saltapura to FSC Chandrapur are based on state highways and national highways acting in 2015. Notification of Tripura State Government dated 23/4/2005 is the basis for establishing the extent in 2015 of this route mentioned. It is very categorical that there existed at 3 routes mile. The route has been given in the box mile A, B, C. To reach the FSC Chandrapur, there are 3 routes. One is showing 343 that earlier committee has gone through. The middle B is 300, approximately 900, and C is 285 to 295 kilos. But next page, what are the maps quoted there?
This addendum is which date? Date of?
This addendum is my lord dated 29/8/2020. Next page is
98. Yes.
the route is from Saltapura to Chandrapur. Next is the map given. Teliamura is the common place. From here, there takes a 3 types. So from Saltapura to Teliamara is the common place. Now, Teliamara to my lord. The opposite the extreme left, my lord. Koyapur Highway bypass point, which the earlier committee has taken. He will come to Teliamara, Koyapur, then take the Amtali bypass, bypassing Agartala, then come down below to Udaipur and then FSC Chandra. That is route A. Now route B, Teliamara to Champak Nagar, then will come to the Udaipur and FSC Chandra. And the routes, that one is route C, and the route B, Teliamara to Amarpur, then FSC Chandra. This is 90. Now next is
Yes.
219. This is the notification of Government of Tripura issued in way back in 23rd April. only in the year 2015, it existed in the year 2005 also. Date type,
Yes.
23rd April 2005, my lord, notification. Your lordship will kindly come to serial number 3. Powai to Teliamura, Amarpur. And then then 7, Amarpur to Uday.
Yes.
So this is 108 kilometer and this is 43 kilometer. That is comes to 40, 151 mile. Then another for
You are reading in this notification, which serial number? 3.
3.
108.
Teliamura to Amarpur. Powai is the also common place, my lord. It's above Teliamura. It is not showing in the this map, my lord. But
Hmm.
Teliamura is the common place. Kalchapra, Teliamura is one term.
And the other one?
And the number 7.
Amarpur.
Yes, Amarpur to Uday.
But there are further places also. Kakraban, Malagar.
It goes further, my lord, but Udaipur to after the Chandrapur is nearby. Udaipur is common. If your lordship will again kindly see page 45, the route B matter route. Teliamura to Amarpur. The route B. First one,
Yes.
Teliamura, down below is Amarpur, and then Udaipur. Then this FJ.
Yes.
So this route was existing year 2005 from 2005. That earlier committee report has taken the longer route map. And this addendum, this report has not been challenged.
Which report not challenged?
This one, my lord, the report and the addendum, committee report and the addendum. So, my lord, the facts remain that 90 was exactly kilometer which was quoted in the annex. After first public, that may be taken. Yes, sir. Yeah.
Yes.
Court, Honorable Supreme Court, order matter. So, take on. So we are not inclined to interfere with the judgment, the question of law offense while here that not state that. That because certain anything has not been observed. So my committee report has not challenged. Now there exists a question of fact regarding the distance. The petitioner is actually may vote for civil court name them completely there that no, there is only the 40 kilometers and that shorter route was not accessed.
Mr. Sawale, are you aware of this Supreme
Well,
Court?
But my lord, that is regarding CPO, things, my lord, first case. Second case, my lord, is not there.
So it has
What?
nothing to do with
My lord,
in this
my lord,
read
that I have, our, my lord, just now he has read only one line, my lord,
No,
he
no,
said.
let him finish, then we'll come to you.
Hmm.
But I was just asking, are you aware of this Supreme Court?
No.
And any trade, there was specific per empty per kilometer. Here is the entire distance. And the Honorable Division Bench in my report, the concern has stated specifically, will not go into triple mapping. And the chief of the case, the almost report has said that not. So it has to be dealt independent. Neither any trade will come in to help. So he has not challenged the committee report. Now the question of fact regarding the entire distance matter is claiming 343, whereas we have documented that it was not 90. He can approach the civil court. That's all.
Yes, sir.
My lord, here, they have come to, my lord, that calculation, which is page 183 of the affidavit.
Yes.
So your lordship, the last tenderer, rate quoted by tenderer, quoted rate converted into per kilometer per metric. Next page, your lordship sign, my lord. Our rate was, my lord, 2759. The distance mentioned, so 944 per metric ton per. Control quoted more, my lord, 10 point.
Yes.
So I was, the same facts were there, my lord, here, in the second case, my lord, the bill, 26 of the. There also, my lord, the rate was quoted 2549 for the entire distance of. And that I have shown, my lord, to your lordship at page 3 of the judge. Page 3 of the.
Which judgment?
That detail bill 26 of,
26 or 36?
my lord,
26, right. But this Supreme Court has said, don't take this as a
no,
precedent.
that is TB Chaudhary, my lord, that is different as told.
No, 26 is Jimmy Chaudhary.
TB Chaudhary.
26 is Jimmy Chaudhary.
No, my lord, that, my lord, TB Chaudhary was eventually not taken. But facts remain, my lord, that this report, my lord, accepted, my lord, the earlier division bench said, my lord, that the committee report has been found to be good. Report at page 155, my. Yeah.
Huh?
Fine, my lord. Paragraph 15 at page 155.
What is paragraph 15?
Paragraph 15, my lord, says, my lord, that the committee report, we have, however, faced with the situation wherein the tender itself mentioned the distance of 292, the contractor quoted the rate accordingly on the presumption that the distance of the fact indeed could be 292 by immediate intimidation of the contract. When the goods were transported, it came to notice of the contractor that the distance in fact was more, and therefore to consider opinion of the court as well as in time contractor objected to the distance by communication to asking the FCI to recalculate the distance because there appeared to be a road further evident that from the report that the objector taken by the contractor was noticed by FCI that the committee was constituted for the purpose of calculating the answer distance. Indeed, the objection of the contractor was found to be the based on the fact. Instead, 292 kilometers, the distance transportation goods has been found to be 343.2 kilometers. To this effect, there is no dispute, and the appellant FCI admits. So this is the admitted well.
Well,
This-
my
this-
here
since he
2050,
admitted.
man. But
And now, my lord, after so many years, my lord, I have always shown, my lord, the earlier committee has gone there, actually went there by vehicle and calculated distance. And they have given the note, my lord, that the two other routes are not where trucks cannot fly. Now, this committee also, my lord, I have placed before your lordship, my lord, the present committee, what they have said. They have examined for maps, my lord. At page 207. They have examined for maps. And the second addendum also, my lord, says that addendum, my lord, for some currently existing major roads, district roads in the state diplomat constitute currently the shortest motorable road. Thus, the committee could not ascertain if the roads were existing in 2015. And it consists of fact that some of them were non-existent in 2015. Therefore, no comments were made against it. I think, yeah. That's why I prepared, my lord, the written note of my I just I put it this, my lord, tonight. So their committee itself, my lord, could not touch. How? can- And they have not objected so long, my lord. They said, my lord, they have not also committee. Now they have come, my lord, on a basis of maps, my lord, they said, no, sorry. So people may have, my lord, they are from this highway, but this highway, my lord, is there at that. Now many are developed. Roads are new, roads are. My humble submission that honorable court will not take the cognizance of that because they themselves say that on the maps they have found it, they have not gone there personally because that was not the direction of the department alone that to go and physically see. And they could not ascertain also, my lord, whether this could be existing or not. My humble submission that in the case, my lord, that
one that. But. Page
Page?
89.
Yes.
There is Fox Road, there are 4 routes
Yes, yes,
given there.
yes, yes. Yes,
Third one pertaining to this seat.
yes.
Now, fourth one, there is a distance of 23.9 kilometer at the first column.
Hmm.
Beginning point of doesn't pertain to this case, but there is a asterisk.
Hmm.
23.9 kilometers.
Yes.
Against this asterisk mark, there is a remark down below which my 20 the time, so
Hmm.
not applicable. There are 3 ways that lead to main road national highway via Kailan, but out of that, lorries, trucks can fly only on one road. Other 2 roads both populated village area. It's not important. It's
Oh, this asterisk is not for,
not for Salchapara
no, Kaline is
to-
there.
to Udaipur.
Same.
Uh,
It is same, my lord.
Asterisk mark 14, my lord, that
Oh.
Badarpur Silchar, my lord, diversion point.
My lord, if your
Technique
lordship,
point of Bihara sighting and via way.
if your lordship see, my lord, both are same. Both are same.
How-
Badarpur is Silchar, the diversion point is Badarpur Silchar. See? And Kalain is not here, my lord. That's why that Kalain has been mentioned.
That only particular point, my lord, beginning
Bihara
point of Bihara
sighting.
sighting via Wavry, Badarpur Ghat.
Mr. Sayola, see, there are three components in both the third box as well as the fourth box.
Yes.
First, so far as your case is concerned,
Yes.
the second and third rows are exactly the similar. We are not on those.
Yes.
But what Mr. Singh is perhaps trying to show that the first row,
First
so
one.
far as your case is concerned, beginning point of Salchapara siding via Way Bridge to Badarpur Silchar diversion point, yours is 14.5 kilometers.
Yes.
Now, on the other hand, so far as the fourth box is concerned, the first row, beginning point of Bihara siding via Way Bridge to Badarpur Ghat Silchar diversion point. The starting is different. And in this context, the asterisk is given. This 23.9 kilometers has to be read at the asterisk. There are three ways that lead to main road via
Very
Kalain.
good. Now, next, my lord, next, it is to mention that committee has strictly followed the shortest portable road so the which lorries and trucks are flying.
Hmm.
A road map consisting of the point-to-point road distance recorded by the committee is enclosed for it. So they have picture also there. A recorded by there, next page, 80 and 80.
No, Mr. Singh, even if we don't take into consideration this part, asterisk parts, then also this committee says it's 343.
Yes,
Well, technically longest,
Why?
shortest,
Wait.
343. That I have gone from the addendum notification, my lord. Addendum that page 245.
No, but how do you overcome the submission that this committee report is based on a physical verification by traveling, and the other one, addendum, is by only on the basis of maps?
And the government notification.
Government notification, okay, but
There is a
now when a dispute was raised and it had physically verified, on documents there may be something else, but on physical verification, how have you discarded your own report?
that is why my the authority has in our affidavit we have stated take action.
Now, what action has been taken?
Give it tomorrow.
Now, what action has been taken? Is it one officer or a group committee? Committee. You tell us what action has been taken.
No.
Okay,
Right.
we'll have a second half. But that is besides the point. But you first
Yes.
tell us. Let us know about the action. 2000. Okay, we'll continue we'll just close at 2 o'clock.
Then
No, what kind of action?
the documents have not yet. Sometime.
Okay, heard from huh? Or the answer is state by S2D. S2D or for the BKC for the respondent FCI. Hearing is concluded, judgment is reserved.
Oblige.
Hello.
Made it. Lordship, the petition at the capital and by an order dated 21/9/4, page 50, the top of the petition were attacked. Subsequently, the Honorable Court order dated 9/1/2025 may kindly be paid.
Nine?
9/1/2025. Order dated. Second paragraph.
Yes.
By order that the what have instructed the government advocate whether my shop was above 50 cars as on 26/6/2021. What happened, Lordship? Although I have all the requisite qualification and my shop is since 1992, while point of sale devices, there are people's device, point of sale device,
Hmm.
a device by which the sale is executed.
There are two petitioners.
Lordship,
You have two shops.
Lordship.
Okay.
And it was device they are not supplied. And then, Lordship, the impute order, by the impute order, my shop has been taxed to the other shop. Now, I have above 50 shops all along.
50
50
Consu-
cars, 50 cars, Lordship.
consumers.
50 cars. Page 40, your Lordship, their own communication, Lordship.
Both of you have different.
Lord, page 40, maybe spare this for a moment. This is the communication issued on 5th of August 2024 by who is the Assistant Director of Food Civil Supplies communicated Commissioner
Yes.
for proposal of issuance 7 numbers of proposed device.
Page?
Page 40.
Go ahead, my lord. As far as they are both for my lord,
Yes.
we have information. As far my lord, we have received information from the commissioner. He says that my lord is less than 50. Otherwise, my lord, the political data says that more than. That's why we are asked to verify and clarify the
Okay.
extent.
Yes, what is your?
Their extent we have not yet, my lord, kindly 7 days.
Okay.
Lordship, for a moment,
That is some my lord, that
flag
will be my
mark
lord.
flag mark.
Yes, we've seen.
But since our dispute is badly affected, Lordship, we are dependent on crop loss.
Only 7 days, my lord, already I have talked.
Okay.
My lord.
Oh, okay.
And
7
this letter is very clear, Lord. It's given the
What is your name? Ar Islam?
Lord.
Heard Sri Ar Islam Learned Counsel for the petitioners, who has also referred to the order dated 9/1/2025 passed by this court and subsequent orders thereafter. Full stop para. Sri M. Chetia, Learned State Council, however, submits that some more time would be required to get the instructions with regard to the number of consumers which were attached to the shops, fair price shops of the petitioners, of the two petitioners. Para. As prayed for, time is granted, 2 weeks time is granted, list on, we give a date, list on. 27th, 1, 2, we had on 10th, 10 June. 10 June come up with instructions.
I have already.
Obliged.
I didn't see.
It's a five very further. Step 2.
Okay,
So papers were but that was
yes, instructions,
Lordship, just
okay, it has been done, okay. What is your name?
Miss
R?
R.
Lisa? Learned Counsel, are you on record, madam?
Yes,
Or R Jugli, okay. heard Ms. R. Jugli, learned counsel for the petitioner, as well as Sri R.K.D. Chaudhary, learned counsel for the respondent. What's the para? The instant contempt petition was filed alleging willful and deliberate disobedience of the order dated 9/11/2023 passed in WPC 24152014. Full stop. Notice was issued on 7/3/2025, whereafter the respondents have entered appearance through Sri Chaudhary. Full stop. The matter pertains to a direction for making certain payments. Full stop. Sri Chaudhary, the learned counsel for the respondents, has however informed that such payments have been made in the meantime. Full stop. The aforesaid submission has not been disputed, has been admitted by Ms. Jugli, the learned counsel for the petitioner. Full stop. In view of the aforesaid development, this court is of the opinion that there is no requirement to continue this contempt petition further. Accordingly, the same is closed. Item 9. Item 9. GMDA. None appears for the parties on call. Full stop. The present situation is persisting since 25/4/2024 when none had appeared. Full stop. Thereafter, the matter was again listed on 27/2/2025 when there was no representation from the petitioner. Para. Automatically listen, none appears for the parties for the petitioner on call, whereas Sri M. Chetyalanand State Council is present. Last it appears that the petitioner has lost interest in this matter. Full stop. Accordingly, the writ petition is dismissed for non-prosecution. Item 10. Item number 10. Agotut Lekhiba. This is a matter of 2015. Agotut. None appears for the parties on call. Para. This is a matter of the year 2016. And even on the last occasion, that is 11/3/2025, there was no representation. Full stop. Para. In the interest of justice and as a last opportunity, the matter is adjourned to be listed on or day after tomorrow, huh? Thursday next. Full stop. In case of further non-appearance, this court would be constrained to pass appropriate orders. Yes.
Eleven and 12.
11 and 12. Eleven, 12. None appears for the parties on call. You're there, madam? Then why are you running then? Misleading the court. None appears for the parties on call. Full stop. These matters are pending since the year 2014-2016. Full stop. Para, be that as it may, another opportunity is granted to make representation, failing which this court would be constrained to pass appropriate orders. Para, list on Thursday. Unlisted to Hana.
My first pass of the time. My senior counsel, Dr. Ketu, tax courts.
Okay. On Friday we'll try. Okay, Friday. A prayer for adjournment has been made on behalf of the petitioner. Full stop. Sri A. Kolita Leonard Standing Council, Industries and Commerce Department, and Miss A. Gayan, Leonard CGC are present. Para. In the interest of justice, matter is adjourned to be listed on Friday next. Yes, Mr. Chakraborty, where is your matter? You have to move it tomorrow then. Should have done, we have granted you permission, you should have got it today. Tomorrow?
Or-
He has some urgency, we'll have it tomorrow. Madam, your matters were called upon, you are not there. We have fixed day after tomorrow, but day after tomorrow you'll be here, otherwise you're dismissed for default. One matter you are the respondent, one you are the petitioner. The two matters. One we have already dismissed for default. Not your matter. Item number. Who do dismiss for default portion matter? Item 9. Because there was continuous default. Okay. We'll take up your matter tomorrow, okay? I have to call it police.